protecting trade secrets and intellectual property in times of supply chain shortages. My guest is Terrell Miller. He is an intellectual property partner, counselor, and registered patent attorney with Foley Lardner LLP. Hello, Terrell.
Good morning. How are you, Bob?
Good. Thanks so much for joining me. This is a very important topic, especially we don't talk much about what some of the ramifications of supply chain shortages might be with regard to IP protection. So how and why do you believe that companies today are susceptible to theft of sensitive technology during this time of supply chain shortages?
Yeah, it's a great question, Bob. And really, there's a lot of different reasons, but the primary ones that we're seeing and that I think are the most relevant really come from the recent labor shortages and supply chain disruptions. It's kind of increased the demand. We see a lot with specialized tools in various industries, whether that's the oil field industry or other types of industries. And when you have a shortage of specialized tools and specialized equipment, there's a window there for, I guess, mischievous competitors or companies, or even sometimes your own distributors, to look at the tools that you have and the equipment that you have that are in short supply and look to see if there are ways to duplicate or replicate that equipment and get it into the market. And a lot of times that's done with blatant disregard to contractual protections and certainly intellectual property protections.
But I'm wondering how the shortage situation exacerbates that. Does that mean that potential buyers are more open to the possibility of purchasing purchasing counterfeit or unauthorized types of equipment?
Yeah, Bob, I think you're right. And I think a lot of that is they need the tools, they need the equipment, and they're willing in a lot of instances to maybe look the other way and maybe not even ask the right questions. So kind of a willful ignorance kind of scenario where they may know, and maybe by asking a couple of questions would otherwise find out that the equipment or the tools they're looking to purchase is not authentic.
So where is the threat coming from? Does it come from within, from employees of a company? Does it come from third parties, a combination of the both? Where is the biggest risk?
Really, it's kind of a dual risk, I'd say, really from internally, from employees who may maybe be transitioning from one company to another, going to a competitor, and maybe taking some trade secret or proprietary information with them on projects that they've worked on. But you're also seeing it now, as I mentioned, with the shortages and the increased demand for a lot of these tools, where companies, especially in the oil field industry, they have to have that equipment. They're losing money every day they don't have the equipment. And so those instances, they're often looking for not only competitors or distributors, but even just third-party vendors in the oil field business that might say, you know what, I can make you that tool. I can make you a copy of that tool, and I can do it cheaper. And a lot of these businesses are saying, yeah, I need the tool. I'm losing money. What can you get me? And so again, a lot of times you're just seeing it where a lot of willful ignorance or ignoring the intellectual property protections that may be in place because they need the tool, and they're willing to kind of bend the rules a little bit to get it.
So the threat here is from the actual information or the trade secrets that lead to the production of the physical equipment, right? It's not stealing the actual equipment itself, it's stealing the information required to produce it.
That's correct. And in a lot of those instances, the information is in the form of trade secrets. But oftentimes when tools and equipment go out there, for there to be a trade secret, it has to truly be kept a secret. And if you can reverse engineer it or see the information while you're out there using the equipment, whether that's a customer or a distributor, that's fair game. And so that's where you have to look to other avenues of IP to protect it. And oftentimes that's going to focus on patent protection, right? Because patents are going to protect that useful invention that isn't subject to trade secrets, because you're putting it out into the public where distributors and customers can see it and reverse engineer it. So patent protection is important for a lot of those tools. But again, patent protection is only a jurisdictional protection. So it's good in the US, and it's good in whatever other jurisdictions you choose to file for protection in and are able to obtain protection. So if you only have protection in the US, you're not protected in Canada or Mexico or other places that the copied tools may venture.
But on the other hand, we're talking about a situation that is crucial as a matter of course for any manufacturer. And I would think that just in normal times, any manufacturer would have taken steps to protect its trade secrets, would have exercised patent protection wherever possible, would be doing all the things necessary to protect its IP. You're saying, so what's the difference now? Are there additional steps that need to be taken that weren't taken before, that should have been taken as a matter of course?
I don't necessarily think it's additional steps. I think it's just more of a focus on making sure that the steps you're taking are being thoroughly implemented. And what I mean by that is if you have trade secrets, you need to make sure you're protecting them. You need to make sure that your contracts that you have with distributors or customers have provisions in there that say they're not going to reverse engineer or attempt to learn your trade secrets. If you're filing for patent protection because you don't maybe have trade secret protection, maybe it's the type of knowledge or information that's already public or will be public, then you got to look and see if it's subject to patent protection. If it's subject to patent protection, you got to make sure that you're filing broad patents and that you're filing them in multiple jurisdictions, at least specifically in the jurisdictions where there's a market for the equipment.
I would assume the situation is worse in cases where the supply chain is international or global, which maybe describes just about every supply chain today. Are there any particular geographies, parts of the world where this risk is especially high?
Certainly, there are certain countries that maybe don't have the respect for foreign intellectual property that more developed countries typically do, and even some developed countries that don't really look to respect foreign intellectual property protections. And in a lot of situations, the way they also get around it is it's very difficult to enforce intellectual property in certain foreign jurisdictions. I hate to use the term like home field advantage, but in a lot of these countries where tools or equipment are being replicated, even if you have patent protection filed in those jurisdictions, it's often very hard to really enforce it in a meaningful way, because the courts of those jurisdictions really aren't interested in hurting their own economy by having foreign intellectual property enforced against their businesses.
Okay, so let's just reiterate. I want to make quite clear what you're recommending that companies be doing now in this particular time in order to protect trade secrets and intellectual property. Just run down for me like some of the main points that they need to keep in mind.
Sure. And the first one we'll start with is trade secrets. When you've got information that is truly proprietary, and what I mean by trade secret is something like the Coca-Cola formula, where you're not giving the information out publicly, right? I mean, Coca-Cola puts all the ingredients on the side of the can, but they don't tell you the secret recipe. And that's what I'm talking about there with trade secrets. If you have something that is not able to be reverse engineered or reverse engineered easily, you need to make sure you are protecting it as a trade secret internally with your employees and externally with any vendors or contractors that may have access to the information. And that's going to require contractual protections, password protecting files, things like that you would think are normal with maintaining information as a secret. Additionally, you're going to want to look at contractual provisions against reverse engineering and sometimes territorial use when you're maybe selling products. Contractual provisions can oftentimes help get you rights where trade secrets aren't going to be able to help you, maybe because the information is public or can easily be reverse engineered. And you can also think about licensing out the equipment, almost like a rental or a lease type arrangement instead of outright selling it, because then you're able to still maintain control of the equipment and tools rather than just selling it outright. And then, of course, intellectual property protections. The one that's the most important here that I'll stay focused on is patent protection. Now, patents are not the easiest thing to acquire, and they do take time to get. But as long as you have a robust patent portfolio that's covering a particular piece of equipment or tool that is truly innovative and subject to patent protection, you should be looking at particularly protecting it in the jurisdictions and countries where the market's going to be there or where you think the market's going to develop. And you have to kind of have a lot of forethought on that, because if it's something that's innovative and new, it probably hasn't been introduced to the market yet, at least not in the form that you're attempting to patent it. So you have to kind of, think forward as to which jurisdictions you think the market will develop. So really, those are kind of the key points. To reiterate, you want to make sure you're protecting your trade secrets. You want to look over your contracts and protect not only what your employees are doing as far as taking information to go to a competitor, maybe trade secret information, but also the contracts with your distributors and customers to make sure there are protections against reverse engineering. And you might also consider licensing out the equipment as opposed to selling it, because then you're able to maintain your control over how that equipment's used and where it goes. And then lastly, of course, is patent protection. And really, if it's something subject to patents, getting it out there and getting it protected in the jurisdictions that matter to your business.
Terrell Miller of Foley and Lardner, thank you for that great advice as to how companies can protect their trade secrets and their IP at a time when they are especially at risk in this time of supply chain shortage and crisis. Thank you so much for being with me today. Appreciate it.
Thank you, Bob.